Hello, everybody, and welcome to our last webinar in our summer webinar series, Insights from IMAC. I'm Marissa Levy, the Marketing and Events Manager here at MPA, and today we're going to be talking about data privacy and hopefully answer any questions you may have about that topic. So today we have an excellent panel of speakers. Richy Glassberg is the co-founder and CEO at Safeguard GDPR. Then we have Brigitte Schmidt-Gwyn, who is the EVP Government Affairs at MPA. And then we have Matus, the co-founder, general counsel, and chief compliance officer at Safeguard GDPR. So I'm going to turn it over to Brigitte, and she's going to start us off.
Hi, good morning, all. So I'm just going to give a quick overview of what's going on from a political landscape in the privacy space. And so let me just start with this first slide at state privacy legislation. And what I really want to call, this is a slide I showed at the IMAG meeting, but there's been a significant change, and that really is that Nevada has recently passed a bill toward the end of May. There are really kind of just 3 or 4 things that I want to highlight about what is different from California versus Nevada. And really, I would kind of say Nevada is a California light. The first area of difference is that Nevada applies to data collected online by an operator of a website or online service, where the CCPA applies to data collected by a business online and or offline. The second area of difference is information that's covered by law is narrower for Nevada than it was in the CCPA definition for the term personal information. Under Nevada law, the covered information is personally identifiable information. And then the third area of big difference is in the definition of the term sale. Nevada law requires the party receiving the data from the operator to subsequently license or sell the covered information to another person. So those are kind of the three of the biggest differences between the laws. Let me just say, if I have a little bit more of a deeper summary of each of these provisions, and if anyone is interested, I'm happy to forward that to you. You can just email me at Brigitte S. Schmidt Gwyn, Gwyn, so bsgwyn @magazine.org. So that's the major difference. Just very quickly, there's still some activity happening in major states. I'll get to California in a moment, Massachusetts, New Jersey, New York, and Pennsylvania. We're keeping an eye on all of those and engaging with our industry peers. Any questions on just kind of the overview? Okay, let's keep going. Marissa, if you could go to the next slide. So really,
just a reminder to our attendees, if you have any questions throughout the webinar, just type it into your question box on your screen.
Great. So just real quick on CCPA timeline, I think everyone's pretty much aware of things are, but bottom line is the legislature is in recess basically right now through the middle of August. Right before they left, the Senate Judiciary Committee held a hearing on the CCPA. A number of amendments were offered, very, very limited number of amendments passed, and those that passed made very limited changes. So as of right now, the CCPA still basically stands as is. What is going to be happening over the next month, we're working with a number of other business groups on possible amendments. And we are hopeful that we can make some progress. Senator Hirschberg is kind of leading or championing the effort to find some compromises around the bill. That will be voted on when they get back mid-August, and the bill will be signed into law by the governor by mid-October. Obviously, we still have to go through all of the rules and regulatory process and interpretation of the bill. There's a little bit of uncertainty on if the AG has this role and responsibility, or if the legislation may create a commission that's specifically focused on privacy. If the commission moves forward, it could delay things, but I think no matter what, we really are looking at an enforcement date of July 2020. Again, we will be continuing to work on, can we make some improvements on this, and we'll stay focused on that over the next 2 months as we move through the legislative process. So with that, that kind of just gives us a quick, and let me just mention one other thing. There's not a slide on this, but ultimately we are trying to move something at the federal level. No surprise here based on what's going on this year in the Congress. There really seems to be no appetite for doing a federal bill. You know, my best guess is that this is something that doesn't probably happen until 2021. We have to get past the presidential election. That said, we have started meeting with members of Congress. We've met with the chairman and ranking member for the subcommittee in the Energy and Commerce that would have jurisdiction over this issue, Jan Schakowsky and Kathy Morris-Rogers, about legislation that they're both working on for their parties. So we'll continue to start to build those relationships now and start educating as they start to develop something. So that very quickly is what's happening at the state level and federal level. So with that, why don't I pass it on to Richy and Wayne?
Thank you, Brigitte. It's great to be back in front of this huge crowd again. We had a great time in Charleston, and we're happy to be back on the interweb in front of everybody. We've taken the liberty of updating Safeguard GDPR's top 10 steps to prepare for the CCPA by adding the Nevada law. So what we'd like to do very quickly is take you through just 2 slides, going through the top 10 and where there are changes in those 2. And then we've got some pre-asked questions, and we have the ability to answer questions as well. Marissa, can you go to the next slide? So we think that we want to make sure everybody understands. We said this on stage in Charleston, and if you weren't there for the IMAG, it's more complicated than these 10 simple steps, but we do believe to summit this mountain, you got to start your journey. And by starting your journey, we've tried to give you a strong foundation and 10 basic steps to allow you to begin building a strong CCPA and Nevada compliance program. Next slide, please. We've taken the liberty of updating these slightly from our meeting when we were last together. Wayne, do you want to start taking us through the top 10 steps?
I will start by doing that, thank you. But before I do, I'd like to actually make 1 or 2 fairly preliminary comments, since Nevada is so new to people. Nevada has come, I think, to many people as a surprise as to how quickly the law was passed and takes effect. It takes effect on the 1st of November. There are quite a few differences, and you just heard from Brigitte and Marissa about things, and in particular, you just heard the 3 most important or significant differences. But let's try and put this a little bit into context, if you will. California, depending upon how you count it, either gives 5, 6, or 7 rights to individuals. Nevada really just gives 1. It is not as complicated a law in some respects, but definitionally, it's more complicated in other respects. If you're thinking about Nevada law and you're thinking about doing a compliance program, and you're thinking about the fact that Nevada goes into effect November 1, and you bear in mind that while California enforcement starts in July of next year it will look back 12 months to data that you begin to collect in July of this year. You begin to start to figure out what it is you need to pay attention to. And in particular, if you're involved in the sale of data, Nevada is concerned about the sale of data and provides the right for Nevada residents to opt out from the sale of their data. California provides that right to California residents. So if you're going to be paying attention to what I need to do first, I'm going to suggest to you, it's not in the slides, but my suggestion would be there are two things you ought to be paying attention to first. One, your ability to handle those requests to stop the sale of data. The sale of data in Nevada is defined quite differently. The opt-out right is quite different from the California right. You really need to be familiar with each, and you need to be able to address them and address them soon. And then additionally, they have different notice provisions. And you need to get in touch with what those are and address those in your privacy policies and your means of communicating by 800 number or web page or the like, because there are differences between those two laws as well, but there's overlap. And there is the capability of dealing with these two specific legal provisions now, which are the provisions that are going to come to play and be the most difficult for you to deal with. So that's my first suggestion as to what's different. Now, going through the slides, if I might, I think it's become pretty well established that you can't deal with consumer data however you define it unless you understand your consumer data. So when it says what types of information you collect, store, bought, used, shared, or the like, knowing what you have is important, and understanding under Nevada that there's a difference between personal information and consumer information in the Nevada statute itself. They are different defined terms with different meanings. So when you talk about what types of personal information you have, you actually need to get fairly granular as to exactly what is it you keep on people, what you collect versus what you might have bought from someone else, and what you use and what's shared and the like. Nevada, for example, only deals with information that you collect, whereas California will deal with any information in your possession. I'm not going to continue to highlight the differences between the two, but I want to make it very clear that you can't just treat one as a light version of the other. They are, although it is correct that Nevada is lighter, it's lighter in a very different way. The second thing that you need to do is to know where your data is and how it's kept. And why is that important? If you have to tell someone what data you have, you best know where it is. And if you have to delete that data, or in the case of Nevada, prevent the sale of that data, you best know how it's kept to know whether you have the capabilities of complying with the law. The third item listed is able to provide the information in portable form. This is a standard that's important under the GDPR. It's a standard that's important in California law as well. Are you able to get that data out so that someone else can utilize it? Fourth item listed.
Wayne, can we just take a 2-second break just to ask the crew to see if we've thrown a lot out? Can we just take a 30-second break to see, does anybody have any questions on, Wayne's thrown out a lot of, golden nuggets. Sorry to do that. It's Nevada. I had to, but he's thrown out a lot of good stuff. Is anybody have any questions online before we keep going? Don't forget, you can just go to the question box on your control panel. You can type in a question, and Brigitte, Gwyn, and Marissa and myself can see it. Okay, Wayne, you want to keep going? We'll stop again after 6, so we'll go 4, 5, and 6, and then we'll take another break. Wayne, keep going. Thanks, pal.
With regard to can your company comply with tight deadlines, the CCPA has a deadline for providing data. Obviously, you can't do number 4 if you can't do number 3. So one had best do number 3 first, and then one best be able to do it within the timeline of 4. But that's not the only timeline. Nevada has timelines too. Nevada gives you 60 days in order to report back to a consumer that has asked you to not sell their information, that you're not going to sell it, and only gives you a 30-day additional period, and only if you have a reasonable basis for doing that. So you're dealing with 30-day, 60-day, 45-day timelines. That's not a tremendous amount of time if you haven't lined up where your data is, how you keep it, and how you get at it. You're not going to be able to deal with the deadlines when they come and hit you. As to item number 5, that's very much California specific in terms of what it is that you have to be able to disclose. But again, the significance of this is going to be when you do this disclosure come July of next year, they're going to expect you to go back 12 months. And you may have faced the option of having to delete that information from which is valuable to you. You may have to delete it if you're not capable of complying with the CCPA, which is not very desirable. So it once again highlights the importance of acting now. Those are the first 5, Richie.
Great. Marissa, can you scroll up? You want to do 6, and then we'll take a break and see if there's anybody's got any questions. If you've got a question, just throw it in the question box. Oh, there we go. Hold on. Let me, where does behavioral data connected to a third-party cookie fall into these laws? And then there's a corollary question, same question for first-party cookie.
Let's not keep multiple questions in my head at a time. Let's do one question at a time.
So the question is, where does behavioral data connected to a third-party cookie fall into the laws?
Behavioral data is personal information. It's not going to, more likely than not, be considered in the definition of personal information in Nevada. And it's certainly, the issue is, the question that was asked was collected by a third party. Is that correct, Richy?
Yep, third party. Yep, connected to a third party cookie. Yep.
Well, connected to a third party cookie doesn't mean that that isn't a cookie that you've put in and that you're utilizing. So the answer is I would take a closer look. I don't have the statute in front of me, so I don't have it memorized. That's in Nevada. I don't remember that a behavioral characteristic falls within one of their 7 categories. I don't think it does, but I'd have to study it. And with regard to California, you're going to have to deal with it. That's the type of information that you're going to need to disclose. And it may well be, again, I'd have to look specifically at the language of the notice provision in Nevada, but that type of a practice is, my suspicion is that that's a practice that you're likely to have to disclose under the Nevada statute. One of the things I want to very quickly say is, those are good questions. And there's no way that one can answer those questions without actually looking at the text of the law itself and both understanding the exact language of the law and then what the law might, and the inference you might take from the intention of the person that drafted it.
So Wayne, I think, Wayne, to help out a bit, let's assume just by industry norms that the question is the same question about behavioral data. Let's assume the third-party cookie means it's coming from the other side. That third-party data is more likely coming from an agency, from a live RAM, from a data player. And then in the first-party cookie, that would be behavioral data that the publisher is collecting. So would there be any difference if it was clear it's behavioral data? I guess the question is it different if it's third-party or if it's first-party?
Well, the answer is under Nevada law, yes, and under California law, no. Under Nevada law, it has to do with whether you collected it or not. You have to stop using what you collected, and by stop using, I don't mean you can't use it. You can use it. Let me take that back. You can't sell it for resale. Nevada is really more of a data broker restriction law than anything else, because the restriction is on your selling that information to someone else who then is going to sell it to a third party. It's meant to stop the proliferation of data, not you're using it and not you're using it with one other person directly in privity with you. So go ahead.
Wayne, I want to try to help the publishers online. I'm going to do a little industry insider baseball to try to see if I can drill you down a little bit more. So let's focus on the first party in Nevada. So hopefully everybody understood that California, it doesn't matter if you collected it or the third party collected it, you can't sell it. In Nevada, it's if you collected it. So say that publisher A, an MPA member, collects that first party behavioral data. They can't sell it to anybody else, but is it considered a sale if they're using it in the media buy they are selling to an agency? Or do we believe that that's still going to be allowed because the data isn't being sold to the third party to use it, it's being used to execute on the media plan?
The restriction is placed upon the person that collects the information. And that restriction is not on their use, and it's not on their use. It's not on the sale of the information or the leasing of that information to someone else directly by them. It's on their selling it to a second party who will then resell it or release it to a third. So if you have the behavioral data, you're not restricted, but you can't sell it for resale.
Okay, I think that was very, very helpful. Hopefully we answered your question. I don't want to say the name, but hopefully we answered your question on the behavioral data. And just to summarize, and Wayne will correct me, if it's California, you're restricted to selling that data if it's both third party or first party. In Nevada, it's just if it's first party.
We're talking about a consumer's right to opt out. That's what we're talking about now. So we're not talking about other rights. And with regard to opt out, your statement's 100% correct. California, the opt out right is a blanket, I can opt out of everything. Whereas Nevada opt out is a third party limited sale opt out. Very different.
Yep. All right, Wayne, do you want to go to number 6? I think that's where we are next.
Well, 6 is the point that I averred to at the very start, and I think it's critically important, frankly. It's probably the easiest thing for people to be able to do, and that is to update their policies or be prepared to have their policies updated on the effective dates of the law, and included in having the policy provisions changed is doing whatever procedures you need to implement those policies, frankly, as quickly as is possible. But knowing what it is that you have to do by policy, the sooner the better, is going to enable you to comply. If you don't do that, I don't know how you can even frankly begin. So that's the critical step, and one that one should turn to now. As to consumers exercising their access rights, that's really very much a California provision, and something that one's going to have to be concerned with, but you do have until July of next year to be able to handle that. So that's at least one positive thing in terms of time. the ability to comply with the data deletion requests. There is no deletion requirement in Nevada. The CCPA does have that deletion right. And so you need to know that your systems can do that. That's why that's one of the earlier steps we talked about before. Number 9 is the opt-out right, and we spent a considerable amount of time talking about that. And then finally, with regard to training, again, that's California specific. There are, my view is really the following. The first one is not my view. The first one is you just have to read the statute. The statute says that an individual that works on dealing with privacy for a company or faces consumers has to be educated as to those rights. And the reason why you need to do that is not only can the employee be liable under California law, but the company can be responsible for the employees and their failure to be educated. So that's an absolute must. And any company that wants to protect itself, much like you have an anti-discrimination or harassment policy, you ought to have a consumer data policy and training on individuals to make sure that they understand that. Because otherwise, this is why companies get sued along with individuals for discrimination. They don't train. So that's number 1. It's a must. More broadly, I think that there should be some level of training for all employees, only because you don't know when an employee gets transferred. You don't know what an employee might do that might touch upon a consumer's rights, and you just don't need to have an allegation in some complaint made to the Attorney General or some class action lawsuit that says that individuals in your company weren't properly trained and you were willful and reckless and didn't care about privacy, which some plaintiff's lawyer is going to throw in there like they throw in the kitchen sink. It doesn't hurt, and it can help to just train everybody and go spend the 30, 45 minutes like you do with all the other policies that you have in training for them. That's general advice as dealing with what is effectively both Nevada and California at this point. Let me just add, it would not be surprising for there to be another 12 states or more with laws as varying as Nevada is to California being passed. So you're going to have a completely different set of laws that overlap but have significant changes. It wouldn't be surprising if we see a dozen of those in the next year or so. You just have to look at this somewhat logically. There's an election coming. It does not cost a state representative a dime to say that I was involved in passing something that protected your privacy. So people are going to run on it. That's number 1. Number 2, every bill that I've seen, and I've looked at the sponsors of those bills, all of the sponsors are Democrats. And it looks like, and this is a position that Nancy Pelosi has been in favor of, which is states' rights in this area. So it looks like this could very well be one of the political footballs that gets tossed around on election time. Very, very possible. I would be very concerned about doing some of these fundamental things just in case you find yourself 6 months from now with 6 more states and you're way behind.
Thank you, Wayne. Appreciate you going through that. We have another question from the crew. I'm going to read the question, and I think I'm going to ask Brigitte first on this. The question is internet-based advertising. Does this mean if a consumer wants to opt out, we must disable the setting of third-party cookies on our website? Or is it sufficient to ensure all cookie partners to use and comply with the industry opt-out services? So, Brigitte, is it the MPA's belief that just because a consumer wants to opt out of having their profile in there, are we taking the industry belief that the opt-out is an ad blocker? Can they see untargeted ads, or what is the MPA's belief, or what are you hearing from the other trade associations Can this be utilized as an ad blocker?
So I would have to say we've not had the conversations to that depth yet, but I'm going to take that away as something to have additional conversations on.
Right. So the question, I guess the question is, and I don't have an answer for this, Wayne, I guess the question is, because the consumer has the right to opt out of their data being used, if it is non-targeted, just, I'm making it up, AT&T buys a homepage takeover and it's not targeted, and they're going to buy every single impression on the homepage of Wired magazine. I don't mean to pick on one MPA member, but, just made it up. Does the CCPA, while it's calling for the right to privacy, does it in effect say that they can't see any advertising? Because to me, I'm not so sure that is the intention if it's non-targeted advertising.
No, there's absolutely nothing that restricts the ads that can be shown to an individual. You're dealing. These opt-out laws are really targeting the sale of data, not what can be shown to an individual. The GDPR has a different twist, but the state law focus is on sale. The GDPR would take it a step further and basically want you to scrub it for all purposes, but that's different.
Did we answer your question on the line? I would also say it would be safe, to the second part of your question, to require and ensure that your cookie partners in your consent string comply with that opt-out. I don't want to say that we don't want you to follow the rules. If you have a consumer that opts out, I think you must follow all the industry standard rules. And I know the IAB has some consent string work going here to make sure that you fairly pass that along. That's correct as well, right, Wayne? Yeah,
that's correct. But again, I would focus more on the sale of information than the use of information under U.S. law. The GDPR deals with the use of information in a more fulsome way than the U.S. state laws are doing.
For the people online, does anybody have a follow-up on that? Or did we answer that question for you? We're here. We'll continue to monitor that. The next question that we got previous is kind of it's a twist on that, gang. It says, and I'll try to read it slowly, seeking clarification on the best approach for publishers to opt out users from internet-based advertising, IBA. Specifically, should we be using directing users to industry mechanisms or attempt to develop other mechanisms? Again, this is just a variation of the last question we had on internet-based advertising. I would say, to be safe, I think Wayne has made it very clear, CCPA and Nevada are the sale of the information. GDPR is the use. In the instance of CCPA, and I would also say for GDPR, I know the IAB's had some problems in Europe, but I think it's safe to say that the industry mechanism may give you a little bit more shelter. But I would also, I'm also of the mind that the law and the GDPR is very, very specific on what you need to do. So I don't believe that it precludes you from developing another mechanism. I would be careful, though, and I'd make sure you check with your counsel. But I would think, Wayne, correctly, that using the industry mechanism is a good first step, correct?
Well, let me first, yeah, it's correct, but let's be a little historical and a little specific if we can. The U.S. Chamber of Commerce had something called the safe harbor, and that was struck down, where companies self-certified. Then they started this new self-policing mechanism called Privacy Shield. and the same plaintiff's lawyer, a guy by the name of Max Schrem, has sued to strike that down, and those that have read, as I have, the transcript of the proceedings have walked away with the thought that Privacy Shield is going to get struck down as well, which means to say that these industry standards are laudable, and I think they will provide you with some protection in terms of what the amount of the fine will be, and might even get you a get out of jail free card for one use. But they really should not be viewed, in my opinion, as a solution, because they've all been struck down. And I'll add a third piece. The GDPR has within it a specific provision for an organization that wants to be a self-regulatory body to be certified by a data protection authority in Europe to do that. And there's a process that's delineated about it. I'm currently working on one with the Judicial Center at the Duke Law School to do this for lawyers. And I don't think that anything short of the GDPR prescribed process for creating an industry standard is going to become acceptable. Now, that's just my prognosis, but I told people 5 years ago Safe Harbor was likely to be struck. It was. I told people 3 years ago that Privacy Shield probably wouldn't work, and it looks like that's about to happen, and I'm making the same prediction here.
Thank you, Wayne. Again, I'm going to start with Brigitte. Next question is, if we provide a subscriber's physical address to our corporate members, is that the sale of privacy data? Brigitte?
I would have to say I bet Wayne has a little more legal expertise in that question, because it really has not been defined further from the...
The hard part about the question, Brigitte, is if we provide a subscriber's physical address to our corporate members, I can't tell the relationship of the corporate members to the person asking the question. Are they saying it's an individual magazine under a corporate group, which would be the same company, or is it a totally separate group? So without that, I mean, it's a little bit hard to answer the question, correct?
Yeah, and we don't have clarity on that I'm aware of.
Well, frankly, it's impossible at the moment to answer the question with certainty because, let's start breaking this up into pieces, okay? I heard this as a California question. So I'm answering this as a California question. If it's a different question, then there's a whole different way of having to look at this. We do not have clarity under California law as to what a business is. Yes, I know that sounds ridiculous, but we don't know what they mean as a business. We can infer from some sections of the law that related companies count as a single business, because when you look at the California statute and it talks about, do you do $25 million worth of business in California, it utilizes the business as being related companies too. And one would presume that what's good for the goose is good for the gander. If you compile the amount of business necessary to fall under the statute, that also should mean you're able to transfer among that control group freely. But no one has gotten the answer to that question yet, and I can see it being litigated.
Okay, that's again a good set of answers from that. I'm going to go to some pre-sent questions because I think we've answered all that the attendees are asking right now. There's a question that was pre-sent saying if our company has various advertising tags on our sites, which may or may not contribute to the execution of internet-based advertising, how do we ensure that we are compliant with GDPR and CCPA? Hold on, I'm going to read the follow-up is, can we be in compliance if we provide the appropriate disclosures, prominently display links to an industry opt-out mechanisms? Gwyn, I think Gwyn has already said very clearly that the GDPR talks about use of the data, where CCPA and Nevada, which wasn't asked in this question, are sale of the data. I do believe it is very important to always have all appropriate disclosures. Don't make it hard for them to find your links, prominently display the links, have your opt-out in multiple places, have your privacy policy there. Look, we're all consumers as well as being in the business. We all know when we're trying to find something on a retailer's website and we can't find it, it's very frustrating. I would argue that best practices is don't frustrate your consumers. It's a tough enough marketplace as it is. Wayne or Brigitte, do you want to comment on that as well?
It would be a really wise idea, in my opinion, for you to have some form of documentation with that company as to what they may and may not do with regard to their use of your site. If they tell you that they're not doing something, you probably can take comfort. Let's deal with the GDPR first. The question is, are you in any way, shape, or form either a processor or a controller? As to that information, you're not controlling it. And as to that information, you may be processing it. And if you are processing it, then if you have a processor agreement, which clearly states what your duties and responsibilities are and that you're not doing more than that, you should be able to avoid liability under the GDPR. You need to write it carefully, but I think that you can do it. I don't see a particular problem with regard to California law, and I actually think you may have a notice obligation. I'd have to look again at the exact language under Nevada law, because Nevada law does speak to the issue of what third parties are doing on your site.
Another question that we got is, how would an MPA member ensure a partner is only using the data for a specific purpose in the context of the IAB framework consent types?
Well, you
Brigitte, it goes on to ask who decides what types of partner is using and what consent types are dependent on other types. Wayne and Brigitte, would it be smart for the publishers at this point to ask either the IAB to give more detail on this, or that it would be with the third party of the partner to make sure you would have an individual agreement with that partner to know specifically what they're doing with the data?
Look, I'm happy to jump in. I mean, this is the Cambridge Analytica problem with Facebook. I mean, in a nutshell, which is, I have data, you take my data and you use my data, and I don't know if what you're using it for, and now I find out it's a nefarious purpose, which then becomes, but did I really know? In effect, Facebook got in trouble because there were allegations that, in spite of what Facebook had as rules as to what you could or could not do with the data, they really knew that what people were doing with the data was something that they were telling them they weren't doing with the data. And so when we deal with this area, it's not enough to just have a piece of paper. If you have a piece of paper that says people aren't doing bad things and you have reason to suspect they are, you're going to get slammed. You have to both have that piece of documentation, and then you need to do a little bit of diligence. How much? That's a great question. I don't have the answer for how much, but certainly not nothing.
The last question that we got pre-done is a question on perspective on the top 10 do's and don'ts around collecting, storing, processing, and sharing data. I'm not sure what the questioner wanted. This was a pre-done question. So what I think would be good here is, Wayne and the MPA, we've been very, very clear that it's very, very important. If Marissa, do you want to go back to the first slide that we had up? I think it's very clear if you go back to number 1 and number 2 where Wayne started. I don't know if you, sorry, not that one, that one. You need to understand your data. You need to know where your data and how it's kept. I think number 1 and number 2, I think, I'll reiterate this. I think Wayne did a really good job in the preamble and Brigitte did as well. You need to know, what do you have? Where do you have it? How do you have it? And how do you access it? I think some people are getting a little bit confused. Just because somebody opts out doesn't mean that that person can't see an ad. Doesn't mean the person, this is not an ad blocker law. This is the ability for the publisher to use and sell that data. And I think you got to get to the building blocks before you can answer a lot of these complicated questions. And I apologize, but it's not our fault. I think the MPA in Washington is doing a great job lobbying in this case. It really is almost out of people's hands that, Nevada has made a different definition than California of what the personal data is. That's not going to make it easier for people. But I think it's something that Brigitte and her team is working on as they're doing the best they can in the lobbying in DC.
Richy, if I might, I just want to make sure that there's not confusion as to one point. California does have a right to be forgotten. And so there is a right for an individual to say, everything you have about me needs to be destroyed. That's right is limited with some common sense things. You can't, for example, tell a bank to go delete information on the debt that you wrote. And you can't tell a company that is owed money for goods that are sold that they now have to delete everything about that person. But there is the ability, there are several rights under California law, as we mentioned earlier, and one of them is that right to not have targeted ads sent to an individual. I just don't want that to be confused. The U.S. laws tend to focus more in the area on sale. Vermont is that way, for example, as well. You see New York in that direction, but that doesn't mean that the right to forgotten has completely not hit our shores.
Right to be forgotten, not targeted ads, is different from, I think people are going to have to think about this going forward. I didn't target this ad. I'm not going to report on the demographics of the user of the ad. That's a fundamentally different change in how internet-based advertising has been sold for the last 10 years or so. But I think that's a larger issue outside of this that a lot of people are going to have to start thinking about. It's not an ad blocker, and forgetting their data doesn't mean that you can't have an ad on a page they're on. It may mean, Wayne, that it's more complicated for the publishers, that they've got a blank tag that is just people that have no data on them, and it's just a blank impression, right? You won't be able to put that into any demographic categories. You won't be able to put that in any behavioral categories. And
that is
just an
right.
impression.
That's
right?
Exactly. That doesn't mean you can send the ad.
Yep,
but you
right. Doesn't mean that, right? Very
Correct.
true. And then that becomes a negotiation with the agency. I would say this, though. We do have to be careful that the agency is not applying a third-party tag and seeing who it is that you've who the impression is and advertising to them when you've asked them to opt out. But that's a whole nother kettle of fish and another complicated thing for the next call. So it's 2:52. We've answered every question that you guys have submitted in the box. We've answered all the previously submitted questions. We'll throw it out, Marissa. We've got like 2 minutes. Do we want to, anybody have any other questions that they want to ask? We don't want to forget that the MPA has done a great job doing a deep discount on the software that we provide. So if you guys want to do that, we're more than happy to help you out with the software. Go with the light sales pitch here, but any more questions or anything else anybody wants to ask? Brigitte, anything you want to say to finish this up?
I just want to thank all of our speakers, Richy, Wayne, and Brigitte, for doing a great job for this webinar. If you didn't get to ask any questions that you thought of after, you can just look out for an email from me. I'm going to be sending out a survey, which we would love if you could fill out. And then if you have any questions, you can just respond to that email. So thank you again. We'll wait a few minutes to see if there are any other questions, but thanks for listening and have a great day.